California is planning a change to its self-defense law that would make lawful defense of yourself, your family, and your home against criminal predators more dangerous for you and enable prosecutors to convict defenders for acts of self-defense that are currently perfectly lawful. These changes put California on the wrong side of self-defense history. Over the last several decades, the laws allowing for defense of self and home have been made more sensible for the lawful defender and more dangerous for the criminal predator. In fact, in my 30-plus year legal career, no state has moved to make its self-defense law more treacherous for defenders and more favorable for criminal predators except California, now in 2025. Let's talk about anti-defender, pro-criminal California Assembly Bill 1333 and what it really does. I am, of course, Attorney Andrew Branca for the Law of Self-Defense, and if you like our content, then I'd like to ask you to hit those like and subscribe buttons, ring that bell. That really helps us out, and it's free. Now, as always, when discussing these legal topics, I like to start from first principles to make sure we're all starting from the same and legally correct sheet of paper. AB 1333, introduced by Democrat Assemblyman Rick Chavez Burr of the 51st District, and I'll include a link to his office in the description, as well as to every case and jury instruction and statute that I reference here. That bill, AB 1333, sets out to make two substantive changes to California's current use of force law, both negative. First, it decreases the scope of defensive conduct that qualifies as lawful self-defense, making it easier for prosecutors to secure convictions against genuinely innocent victims of violent crime who defended themselves against actual criminal predation. Second, it decreases the scope of defensive conduct that qualifies as lawful defense of your home, making it easier for prosecutors to secure convictions against genuinely innocent residents of a dwelling who are defending themselves against actual criminal predators unlawfully entering their castle. If neither of those sound like good things for law-abiding California residents compelled to defend themselves and their homes against the predation of criminals that California itself refuses to hold accountable or imprison, you'd be right. I could probably end this video right there because that's the take-home message I have for you, but this is, after all, the law of self-defense, so let's consider exactly how AB 1333 undermines existing California self-defense law, which honestly is pretty good as it is. The legal justification of self-defense allows for an innocent victim of unlawful violence to use defensive force to neutralize the threat against them. A use of force that is legally justified is simply not a crime and carries zero criminal or civil liability. Whether a use of force qualifies as legally justified as opposed to being simply criminal violence is obviously something that has to be determined, and that's where the law of self-defense comes in. In order to be justified as lawful self-defense, a use of force has to satisfy a series of up to 5 legal elements, what I refer to as the 5 elements of self-defense. These are innocence, imminence, proportionality, avoidance, and reasonableness. Innocence requires that you were not the aggressor in the confrontation, that you are genuinely the innocent victim of criminal predation. Imminence means that the threat you're defending yourself against must be actually occurring or immediately about to occur, and not some past threat or speculative future threat. Proportionality requires that you not use deadly force in self-defense unless you are facing a threat readily capable of causing you death or serious physical injury. Until that point, you are privileged to use only non-deadly force in self-defense. Avoidance requires that you not violate any existing legal duty to retreat before you can use force in self-defense. Importantly, only a small minority of 11 states currently impose a legal duty to retreat before you can act in otherwise lawful self-defense, and California is not one of them. In fact, of the large majority of 39 stand-your-ground states that do not impose a legal duty to retreat, California is arguably the most aggressive stand-your-ground state in the nation, and has been for more than 125 years. I'll come back to that in a moment. And the fifth and final element of self-defense, reasonableness, requires that you had a genuine, subjective, good faith belief in the need to act in self-defense, and also that a hypothetical, objective, and reasonable person in the same circumstances would have shared your subjective belief. In other words, you genuinely believed you needed to act as you did, and your belief was not speculative or irrational or the result of mere panic. So those are the 5 elements of self-defense. Each of those elements can be thought of as a target of attack for a prosecutor. That's because once you have claimed self-defense to justify your use of defensive force, in order for the prosecutor to secure a conviction against you to overcome your claim of self-defense, he has to disprove one of those required elements beyond a reasonable doubt. Importantly, the prosecutor doesn't have to disprove your claim of self-defense in its entirety, but only any one of those required elements. But as I mentioned, not all 5 elements are always required in order for a use of force to be legally justified as self-defense. In particular, the element of avoidance, whether or not you have a legal duty to retreat, is not required by the large majority of 39 stand-your-ground states that do not impose a generalized legal duty to retreat before you can defend yourself. And it's important to keep in mind, the only substantive difference between self-defense in a stand-your-ground state versus self-defense in a duty-to-retreat state is that the stand-your-ground state removes the element of avoidance, leaving only 4 elements as targets of attack for a prosecutor against your claim of self-defense. And the duty-to-retreat states, on the other hand, leave avoidance available as a target of attack for the prosecutor to destroy your otherwise lawful claim of self-defense. And California is arguably the strongest stand-your-ground state in the nation. Now, I'm obliged to point out that you won't find a stand-your-ground statute in California law because it doesn't have a stand-your-ground statute, but statutes are not the only source of law. Appellate courts also create law, especially the Supreme Court of a state. And this is what the California Supreme Court had to say about stand your ground as long ago as 1897, a full 128 years ago. Quote, California law nowhere imposes the duty of retreat upon one who, without fault, himself is exposed to a sudden felonious attack. This state has upheld the defendant's right to stand his ground and meet by force a sudden and violent attack. Close quote. That's the California Supreme Court in People v. Lewis, 1897. And that's been the law in California ever since. In fact, California's law goes further than just allowing the innocent victim of an attack to stand their ground in self-defense. It actually allows that victim to pursue their attacker if necessary for their safety. This is the relevant section of the current 2025 California Self-Defense Jury Instruction on Self-Defense, CalCrim 505. Quote, a defendant is not required to retreat. He or she is entitled to stand his or her ground and defend himself or herself, and if reasonably necessary, to pursue an assailant until the danger has passed. This is so even if safety could have been achieved by retreating. Close quote. So for the last 128 years, California's only had to satisfy 4 elements of self-defense to have lawfully defended themselves. That is, they needed to be the innocent victim of a criminal attack. That's the element of innocence. The attack needed to be actually occurring or immediately about to occur, imminence. They must not have used deadly force unless facing a deadly force threat, proportionality. And they must have both subjectively believed in the need to defend and an objectively reasonable person in the same circumstances would have shared that belief, the element of reasonableness. If a killing was committed by someone who satisfied those 4 elements, California called that a justified homicide, lawful, and not a crime. Now, Assemblyman Burr, through his AB 1333 bill, intends to make a California who kills even under all those circumstances no different than a murderer. They're an innocent person of an unlawful deadly force attack actually occurring, and they both genuinely and reasonably perceive that attack. And if they kill their lethal attacker in self-defense, Assemblyman Burr wants to put them in a cage for the rest of their lives. Why? Because he wants to add a fifth required element of self-defense to California law for the first time in California history, the avoidance element that imposes a legal duty to retreat even if all those other facts are uncontested. That fifth element of avoidance gives the prosecutor a fifth target of attack to obliterate your otherwise lawful act of self-defense, secure a conviction, and have you sentenced to prison forever. But if the duty to retreat is so obviously a good idea, why do only 11 states impose it? Why do the large majority of 39 states not impose a generalized legal duty to retreat? Why have a dozen or more states in the last several decades switched from duty to retreat to stand your ground, but never the other way? And why has California, in its entire history until 2025, never felt the urge to adopt duty to retreat? Well, in large part because the large majority of states correctly recognize that it's all but impossible for a prosecutor or a jury sitting in a comfortable, completely secure courtroom to really grasp the intensity of the stress experienced by an innocent victim of imminent deadly force violence reasonably perceived. The victim who understands correctly that if they do not act in self-defense right now, they will die. Does that victim have the opportunity to carefully scan their environment for some completely safe avenue of retreat as they are reasonably perceiving an imminent threat of death to themselves, to their wife, to their children? In balancing the interests of the innocent defender against a reasonably perceived imminent deadly force threat, balancing those interests against the interests of the criminal predator who is the imminent deadly force threat, is a good public policy to impose on the innocent defender a legal duty to retreat that the lethal attacker has himself discarded? After all, why not put that duty to retreat on the criminal attacker rather than on the innocent defender? That is the choice that every state has had to make, and 39 of them today choose to give the innocent defender the benefit of stand your ground, rather than increase that innocent defender's jeopardy to favor the criminal attacker. Assemblyman Burr wishes to do the opposite for defenders in California. He wishes to create a self-defense law that more greatly favors the criminal attacker and increases the physical and legal liability for the innocent defender. How do we know? Because his bill, AB 1333, says so explicitly. Here's the relevant section of that bill that adds the following language to California's justified homicide statute, Section 197. The blue text here is how they indicate language being added to an existing statute. Quote, homicide is not justifiable, so not self-defense, when committed by a person in all of the following cases. 1. When the person knew that using force likely to cause death or great bodily injury could have been avoided with complete safety by retreating. Close quote. That is the new duty to retreat language. Keep in mind that under already existing California law, a defender would only ever be legally permitted to use deadly defensive force if they are the innocent victim defending against an imminent, unlawful, deadly force attack. But that's not enough for Assemblyman Burr. Somehow, the existing self-defense law of California that has been perfectly adequate for more than 128 years, and that is mirrored in the self-defense law of 38 other states, must now, in 2025, be changed to make lawful self-defense more physically and legally perilous, even for an innocent victim of a reasonably perceived imminent, unlawful, deadly force attack. I rather doubt this is what the law-abiding residents of California, already awash in the crime made possible by soft-on-criminals public policies, were hoping to get this year from their elected representatives. So, stripping California defenders of stand your ground and imposing a legal duty to retreat, contrary to the otherwise uninterrupted history of American states doing exactly the opposite for decades, and contrary to the entirety of California's legal history, is one big change, negatively, made to California's self-defense law by AB 1333. But there's more. It gets even worse. Self-defense, meaning defense of an innocent person, yourself or some third party, is not the only circumstance in which the use of deadly force can be legally justified. Another circumstance involves defending your castle, your dwelling, your residence, your home, what I refer to as highly defensible property, that serves as a lawful person's ultimate refuge from a hostile world. There is no place that is supposed to be safer for you than your own home. Every state has some provision that allows for the use of deadly defensive force in defense of highly defensible property, your castle, that is independent of the self-defense 5 elements that come into play when there's simply a threat to a person out on a public street. Many states will create a legal presumption, explained to the jury, that if the person you shot was making an unlawful and forcible entry into your home, it's legally presumed that that intruder was reasonably perceived by you as an imminent unlawful deadly force threat. You don't need to see a gun. You don't need to have them make a threat. Their act of unlawfully and forcibly entering your home by itself replaces the need to demonstrate the elements of self-defense that would be required if you'd shot that person out on a public street. Current California law has a similar provision. It states that a homicide is justified if committed, quote, in defense of habitation against one who manifestly intends or endeavors by violence or surprise to commit a felony, close quote. So, under existing California law, if someone is reasonably perceived as intending by violence, like a forcible entry, or surprise to commit a felony, like a burglary, in the context of habitation, that conduct is sufficient to justify their being killed by the castle's defender. There's no need for the distinct elements required for killing in defense of an innocent person, because this is a separate legal justification for the use of deadly force in defense of habitation. So what does Assemblyman Burr do? Assemblyman Burr's AB 1333 strips this defense of habitation provision out of California law entirely. As you can see here from the bill itself, AB 1333, all that red text with a red line through it, that's the existing California law being stricken, removed by AB 1333. And in that red box I've highlighted at the very start of that stricken text is defense of habitation. After AB 1333, the only way to justify the use of deadly defensive force is under the traditional doctrine of self-defense, satisfying all the required elements of self-defense and vulnerable to conviction and spending the rest of your life in a cage if the prosecution can disprove any one of them to the satisfaction of a jury. Somebody's forcibly invading your home? That's not enough for the use of deadly defensive force, according to Assemblyman Burr. You have to wait until that invader moving about your home at 3 a.m. armed with burglar tools is actually presenting you, the sleepy-eyed homeowner in his pajamas with a wife and children to protect. You have to wait until that invader is in the moment presenting as a reasonably perceived imminent deadly force threat to you and yours, exactly as if you'd found you and your family attacked out on a public street. That this threat is occurring in your home rather than out on the street, in your home where your wife and children sleep? According to Assemblyman Burr, that gives you zero favor in the self-defense law that he wishes to impose on California residents. Again, we have Assemblyman Burr seeking to change California self-defense law in such a way as to make legal justification more perilous for the homeowner confronting an dark 30 invader into his home, and more favorable for the invader. Again, I rather doubt that this is what the law-abiding residents of California, already awash in the crime made possible by its soft-on-criminals public policies, were hoping to get from their elected representatives in 2025. And that, folks, is what AB 1333 is really promising to do to California's self-defense law. In a state that works its butt off to make it as hard as possible for law-abiding Californians to be able to be armed against criminal violence in the first place, and which is cavalier, to say the least, about prosecuting and imprisoning violent criminals allowed to freely walk amongst its residents. Good luck, California. You're going to need it. Hey, folks, if you like our content, then I'd like to ask you to hit those like and subscribe buttons. It's a big help. It's what tells the algorithm to share our content more broadly. It really helps us out, and it's free. Until next time, I remain Attorney Andrew Branca at lawofselfdefense.com. Stay safe. Imagine the worst has happened and you've been compelled to defend yourself, your family, or your property from a criminal predator. Fortunately, you win the physical fight, but now you have to also win the legal fight that follows. The cost of that legal battle can be enormous, easily hundreds of thousands of dollars. And trust me, how much money you can bring to the legal fight really does affect your chances of being found guilty or not. The good news is that you can guarantee you have the resources you need to be hard to convict with the backing of CCW Safe, a provider of legal service memberships. There are various self-defense insurance companies out there, and some of them are horrifically bad. CCW Safe is the one that I most trust to protect me and my family. I'm personally a member, and so is my wife. I urge you to learn more about why I trust and choose CCW Safe for myself and my family by pointing your browser to lawofselfdefense.com/trust. And at the same place, you'll find a discount code to save 10% off your membership at CCW Safe as well.